In this video, we will begin examining the remedies available to the buyer in the event the seller breaches the contract by never tendering the goods that she was obligated to, by focusing on a specific category of non-monetary remedies, specific performance, and other related remedies. But before we look at this first category of remedies, it's helpful to consider contract remedies more broadly. That is, the remedies available to the non-breaching party when a contract is breached. The same underlying principle that animates remedies under the common law of contracts also applies to UCC Article 2. That underlying principle is to protect the expectation interest of the non-breaching party. Think back to your study of the common law of contracts. What does it mean to protect the expectation interest of the non-breaching party? To protect the expectation interest means to place the non-breaching party into position she would have been had the contract not been breached. Stated differently, to give the non-breaching party the benefit of the bargain. To place her in the position she expected to be had the contract been fully performed by both parties. This core common law principle is codified in Section 305A of Article 1 of the UCC, which reads that the remedies provided by the UCC must be liberally administered to the end that the aggrieved party may be put in as good a position as if the other party had fully performed. So, Section 305A of Article 1 says that all of the UCC's rules and provisions regarding remedies may be applied liberally, may be modified, combined, or ignored altogether for the singular aim of protecting the expectation interests of the party that is the victim of a breach. This aim to protect the expectation interests of the non-breaching party distinguishes contract law remedies from the remedies available under tort law. Remember, in tort law, the aim of remedies is to put the victim of a tort in the same position that she was before she suffered the injury. That is, to restore the tort victim to the status quo ante, the position she was before the tort occurred. Typically, this is accomplished in tort law with compensatory damages, damages that would compensate the tort victim for the harm caused to her as a result of the tort. By contrast, in contract law, the aim of remedies is not to restore the non-breaching party to the status quo ante, that is, the position that she was in before the contract was ever formed. Instead, the aim in contract law is to place the non-breaching party in some future state of the world that the breaching party expected to live in, but that never came to exist because of the breach. That's what we mean to protect the expectation interests of the non-breaching party. Another distinction between remedies under contract law and tort law is that under contract law, damages available for breach are compensatory only. The aim of damages is solely to compensate the injured party for the economic loss resulting from the breach. Tort law also awards compensatory damages, but the nature of what is compensable under tort law is different and broader than contract law. In tort, damages may be awarded to compensate a tort victim for not only her economic loss suffered as a result of a tort, but also for her non-economic harms, for emotional and psychological harms. Those kinds of harms are typically not compensable under contract law. Moreover, the aim of tort law remedies is more than just compensatory. Punitive damages are also available and may be awarded in a tort lawsuit. Punitive damages have nothing to do with compensation. Punitive damages do not compensate the tort victim for her injury. Instead, punitive damages go to punish the defendant in a tort lawsuit and to create a disincentive for other parties to engage in the same kind of conduct as the defendant did. By stark contrast, there are no punitive damages available under contract law for a breach. No punitive damages unless the act that breaches the contract is also actionable as a separate tort. Indeed, we noted earlier contract law's disdain for punitive damages in the context of penalty provisions under Section 718 of Article 2. Recall that section said that contractual provisions that liquidated an unreasonably large amount of damages to penalize for a breach are unenforceable. Instead, the simple, straightforward aim of contract law remedies is to compensate the non-breaching party for the lost benefit of the bargain, to protect the non-breaching party's expectation interest by putting her in the same economic position she would have been had there been no breach. With that context in mind, let's turn to the first category of remedies available to a buyer, specific performance. Recall from your study of the common law of contracts, there are two basic categories of remedies that might be available in the event of a breach. One category is the legal remedy of money damages for the injury caused by the breach. The other category is an equitable remedy, the equitable remedy of specific performance. a remedy that compels the seller to actually perform what was promised under the contract, a remedy that would force the seller to deliver the goods to the buyer. These two basic categories of remedies are reflected under Section 711 of Article 2. 711 outlines the buyer's remedies where the seller fails to tender, or as we will see in next week's module, where the buyer rightfully rejects a non-conforming tender by the seller. 711 provides a sort of roadmap of the remedies available to the buyer in these scenarios. The remedies outlined in 711 include the option to, under subsection 1, to seek damages for breach, or under subsection 2b, in limited circumstances, to seek specific performance. So let's start with the equitable remedy of specific performance first. As we said, specific performance would force the seller to tender the goods. And if the goal of contract law remedies is to put the buyer in the position that she would have been had there been no breach, then specific performance by the seller would seem to be the most obvious way to accomplish that aim. After all, the remedy would require the seller to actually perform her contractual obligation. So it is ironic that specific performance is the disfavored remedy under both the common law of contracts as well as the UCC. Instead, the default remedy is the legal remedy of money damages, damages in the amount necessary to protect the expectation interest of the non-breaching party. By contrast, the equitable remedy of specific performance is an exceptional remedy. Exceptional not in the sense that courts never grant specific performance, but in the sense that specific performance is not the default remedy for breach of contract. It is a remedy that is available only in limited circumstances. Certain things must be true before a court will even consider ordering specific performance. Recall from your study of the common law of contracts, what is required in order for a court to order specific performance in the event of a breach? You might remember that the equitable remedy of specific performance is subject to a two-part test. Specific performance will be available to a non-breaching party only when the legal remedy of money damages would be inadequate to compensate the non-breaching party for the breach, typically because the non-breaching party's performance has some peculiar, unique, or sentimental value to the non-breaching party, such that the value of the breaching party's performance is not easily measurable in terms of monetary damages. Otherwise, if the monetary value of the breaching party's performance could be easily measured, then money damages would be adequate because money damages would allow the non-breaching party to find a substitute for the non-breaching party's performance. And even then, even if a court determines that monetary damages would be inadequate to compensate the non-breaching party for her expectation interest, specific performance will only be granted at the court's discretion. That is because specific performance is an equitable remedy, a form of equitable relief, the court may take into account any equitable factors in determining whether it would be just or fair to order specific performance. For example, a court may exercise its equitable discretion to deny a request for specific performance because it would compel continued association between two unwilling parties, two parties who have lost confidence, trust, or the willingness to work with one another as a result of one party's breach of its contractual obligations to the other. Likewise, a court may exercise its equitable discretion to deny a request for specific performance because it would be judicially burdensome, requiring the court's ongoing supervision of the defendant's, that is, the breaching party's performance. A court may lack the time, resources, or expertise to adequately supervise the defendant's performance to ensure the defendant performs what it was contractually obligated to perform, that the defendant doesn't cut any corners or short shrift the plaintiff. Most relevant to the Article 2 context, a court may exercise its equitable discretion to deny a request for specific performance by the buyer if the seller has already sold the goods that were contractually due to the buyer to another third-party buyer, because in that context, specific performance would cause its own inequity, causing undue hardship to an innocent third-party buyer for the benefit of the buyer who was the victim of a breach. UCC simply codifies these common law principles in Section 716 of Article 2. Specifically, subsection 1 of 716 simply says that specific performance may be decreed where the goods are unique or in other proper circumstances. Note three things about this very short provision. First, it says that specific performance may be ordered. Thus, the statute reflects that the court still retains the equitable discretion whether or not to order specific performance. The UCC does not mandate specific performance in any particular case. The equitable remedy remains within the equitable discretion of the court. Second, This provision says that specific performance may be available when the goods are unique. This is consistent with the common law notion that specific performance is only appropriate where the preferred remedy, that is, the legal remedy of money damages, would be inadequate. Specifically, the idea here is that money damages would not be sufficient to compensate a buyer if the goods are truly unique. Because if the goods are truly unique, that is, one of a kind, then the buyer cannot use money damages that she might get from the seller to acquire a substitute for the seller's goods elsewhere. Stated differently, for unique goods at least, there is no substitute to the goods that the buyer was contractually entitled to get from the breaching seller. Finally, note the provision also says that specific performance may be available when the goods are unique or in other appropriate circumstances. So the seller's goods need not be unique. Other appropriate circumstances may justify an award of specific performance. But what are other appropriate circumstances? It's again circumstances, other than when the goods are unique, where the legal remedy of money damages would be inadequate to compensate the expectation interests of the buyer. Typically, these circumstances would be where the goods are not unique, but the buyer is nonetheless unable to find substitute goods elsewhere. Official Comment 2 to Section 716 confirms this interpretation, noting that the inability of the buyer to cover, that is, to buy substitute goods elsewhere, is itself strong evidence of other proper circumstances. In that case, the court may exercise its equitable discretion to order specific performance, especially where the goods have been identified to the contract, so we know which goods are the subject matter of the party's contract, and where the goods are still in the possession of the seller, that is, they have not been sold to some innocent third-party buyer. Some examples of other proper circumstances include where the goods are not unique, but because of some shortage or other disturbance to supplies, the buyer cannot find substitute goods elsewhere. Another proper circumstance might include when the buyer lacks the necessary cash on hand to purchase substitute goods, or when the buyer may not be able to recover adequate money damages either because the buyer's losses were unforeseeable at the time of contracting, or because the buyer's losses cannot be proven with reasonable certainty, or perhaps because the seller is insolvent or otherwise unable to pay a judgment against it. In any of these scenarios, an award of monetary damages would not be adequate to protect the expectation interests of the buyer, because that remedy would not place the buyer in the position she had expected to be had there been no breach by the seller. The equitable remedy of specific performance is the primary way that a buyer might force a breaching seller to actually deliver the goods that the parties contracted for. Article 2 does, however, provide two alternative legal remedies: the right to recovery of the goods after prepaying for them under Section 502 of Article 2, and the right to replevy the goods under Section 716 of Article 2. Because the right to recover and replevy are legal remedies, that is, legal rights of the buyer in the event of the seller's breach, unlike specific performance, these legal remedies are not subject to the same equitable discretion of the court. But both remedies are relatively narrow in their application, so we will only mention them briefly. Specifically, both remedies apply only in limited circumstances, only where the goods are identified to the contract for sale. Remember, identification is the moment at which the buyer acquires a special property right to the specific goods identified. Recall that under Section 501 of Article 2, identification occurs when the contract is made if the goods are existing at the time the contract was formed and identified by the parties as the goods subject to their contract. Otherwise, identification occurs when the goods have been designated by the seller as the goods subject to the contract. The right to replevy is codified in subsection 3 of 716. It applies where the buyer has a right to possession of the goods that is superior to that of the seller. In particular, replevy requires the buyer to show either that she is unable to find substitute goods elsewhere or that she has already paid for the goods shipped by the seller. The right to recovery is codified in Section 502 of Article 2, and it requires the buyer to show that she has already paid the seller all or part of the purchase price for the identified goods, and either that the identified goods were bought by the buyer for non-commercial purposes, that is, for personal, family, or household use, or after receipt of the buyer's payment, the seller has become insolvent. As we said, both alternative legal remedies are narrow in their application. The equitable remedy of specific performance remains the primary way in which buyers attempt to get goods out of a non-complying seller. So that concludes our initial look at the remedies available to the buyer in the event of the seller's breach. As we said, The legal remedies of recovery and replevin seldom tend to come up in practice. In most cases, a non-breaching buyer who actually wanted the seller's goods would seek specific performance for the seller's breach. But if specific performance is unavailable, if the court denies a grant of specific performance, the buyer's alternative to forcing the seller to perform is the legal remedy of money damages, something that we will turn to in the next video.